Major breaking news. The United States Court of Appeals for the Fifth Circuit three-judge panel that screwed up the suppressor case of United States versus Peterson many months ago, guess what? Just managed to do it all over again. That's right. The gang that could not shoot straight, the three-judge panel that could not shoot straight, pardon the pun down there in the Fifth Circuit, just did it again. In fact, when I read their opinion, I kind of had the reverse reaction of, oh my God, to what just occurred with a CBS reporter reporting on the Taylor Swift announcement. Check it out, my reaction to reading this opinion.
Oh my God. 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 It's under. Oh my God. Oh my God. Oh my God. Oh my God. Oh my God.
Yep, that's right, folks. When I read this three-judge panel decision in Peterson, I said, oh my God as well, but not in a good way. Let's break it down when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so another total mess up by a three-judge panel down there in the Fifth Circuit in a suppressor case that found that suppressors can be regulated under the National Firearms Act. The taxation and registration scheme of the NFA is perfectly constitutional under the Second Amendment, according to this three-judge panel in the case of United States versus Peterson. Now, you may recall this same three-judge panel back in earlier this year issued a decision that said that suppressors were not protected arms. In fact, they were not arms at all, prompting, among other things, an article in Bloomberg Law by moi explaining how moronic that decision was, and a series of detailed videos pointing out that suppressors are obviously arms under the text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed for two basic reasons. The first one is the Supreme Court decision itself in the case of Nysurfer versus Bruin specifically says that any instrument that facilitates armed self-defense is indeed an arm textually under the Second Amendment because a suppressor facilitates, it's an item, it's an instrument that facilitates armed self-defense by suppressing and protecting the hearing, not just of the shooter, but also the people around the shooter in the event of like a home defense scenario. It obviously is an instrument that facilitates armed self-defense and thus is an arm. And beyond that, as you know, if you restrict, regulate, or ban suppressors, what have you done? You've restricted, regulated, or banned an entire category of firearms, i.e. guns that are capable of firing suppressed rounds because you've regulated the suppressors that attach to those guns. So you're effectively restricting a category of guns capable of firing suppressed rounds. So anyway, that big kerfluffle occurred. There was motions for this case to be reheard by the panel again, or en banc by the Fifth Circuit, and out of the blue, the three-judge panel revoked its prior opinion, which so basically indicated a very good strength, a very good sign that they're going to reverse their position. Part of this was motivated by the fact that the Trump administration, the U.S. Department of Justice, came out and specifically said that obviously suppressors are arms under the Second Amendment and have to be protected. But they didn't go on and kind of say that the NFA taxation scheme is constitutional in kind of a weak-kneed kind of argument. That's clearly wrong, and we'll get to that in 1 second. So what just occurred now? So this three-judge panel, having basically tried to save face by revoking their prior opinion, which is totally wrong, has just issued another opinion, and this one is equally dumb, except it makes different mistakes. The prior opinion earlier this year in 2025 made a terrible mistake by saying that suppressors were not protected arms under the Second Amendment. That's right. The earlier decision said that suppressors were basically just accessories and were not protected arms under the Second Amendment. Totally wrong. But then they basically revoked their decision. And now, today, they came out and said that, ready for this, folks? Suppressors are arms for the purpose of the Second Amendment, or at least they said they assume that. But then they go on to the second part of the methodology of Heller and Bruin, which is you start with the text of the Second Amendment and figure out whether or not the conduct of the plaintiff, in this case, Mr. George Peterson, whether his possession of a suppressor is implicated by the text of the Second Amendment. The answer is undeniably yes, because even this three-judge panel just came out reversing course and said today that indeed, possessing a suppressor for your firearms is implicating the text of the Second Amendment because a suppressor is an arm under the right of the people to keep and bear arms, shall not be infringed. But then this panel, which screwed it up before at the textual level, just managed to move on and totally blow the analysis at the second level, which is the historical tradition of firearms regulation in the United States level. And yes, they totally ball dropped this. Here's why. And let me make this real simple. The entire premise of the argument by this three-judge panel as to why the National Firearms Act regulations and restrictions on suppressors, i.e. the taxation requirement of $200, plus the registration requirement of the fingerprinting and connecting the serial number of that suppressor to you, the gun owner, the suppressor owner, that registration requirement, the entire premise as to why what I just described, the $200 taxation and the registration requirement connecting you with the suppressor, with the serial numbers and all that, the reason why that's constitutional under the Second Amendment, according to this three-judge panel, is ready for this. It is analogous to a shall issue licensing regime. This is what the court had to say. In sum, Bruin's presumption of constitutionality for shall issue licensing regimes applies to the National Firearms Act application procedures. George Peterson cannot overcome that presumption because the record does not reveal that the NFA has effectively denied him his Second Amendment rights. Oh my God. What on earth just occurred there? Ah, God, really? I cannot believe we have a three-judge panel on the Fifth Circuit conflating wrongly shall issue licensing regimes for concealed carry with the National Firearms Act requirements. Because the National Firearms Act is not a licensing regime. The National Firearms Act is a taxation and a gun registration scheme. It's a taxation and an arm registration scheme connecting up an individual with, in this case, suppressors. And by the way, as a side note, for those of you who might ask, why are we still talking about the $200 tax on this? Because it went away under the big, beautiful bill. And the answer is we're talking about it because Mr. Peterson, in this particular case, was indicted under the old version of the National Firearms Act for having a suppressor without registering it or without paying the tax. So it's basically he's been indicted under the old version of the National Firearms Act criminal statute and not the current one that has been basically gone into effect thanks to the one big, beautiful bill. That's why we're still talking about these issues. But with that said, it is 1,000% incorrect to conflate shall issue licensing regimes that apply to an individual for the purposes of carrying a gun in his state, let's say, with a taxation and a registration scheme. And this is very easy to know. You don't even have to believe the Four Boxes Diner, although you really should, and most people would, by the way. Okay? You just have to look at an even higher authority than the Four Boxes Diner, and that is Supreme Court Justice Brett Kavanaugh, when he was a judge on the U.S. Court of Appeals for the D.C. Circuit, in his dissent in Heller 2, where he drew clear distinctions between shall issue licensing regimes and gun registration requirements. So let's see what Judge Kavanaugh had to say, pointing out that licensing regimes have nothing to do with gun registration schemes, which is why it was totally improper for the Fifth Circuit to just conflate and use licensing regimes and licensing regime precedents as a basis to uphold the National Firearms Act as applied to the suppressor that George Peterson had. Totally wrong. But let's see what Judge Brett Kavanaugh had to say in his dissent in Heller 2 on the D.C. Circuit, and you'll see the logic and ask yourself, why did the Fifth Circuit mess this up so badly? The fundamental problem with D.C.'s gun registration law is that registration of lawfully possessed guns is not long-standing. Registration of all guns lawfully possessed by citizens in the relevant jurisdiction has not been traditionally required in the United States and indeed remains highly unusual today. In considering D.C.'s registration requirement, it is initially important to distinguish registration laws from licensing laws. Bing, 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 bing. Did you hear what I just said? What Judge Kavanaugh said? In considering DC's registration requirement, it is initially important to distinguish registration laws from licensing laws. Licensing requirements mandate that gun owners meet certain standards or pass certain tests before owning guns or using them in particular ways. Registration requirements, such as the NFA, by the way, registration requirements, by contrast to licensing laws, require registration of individual guns and do not meaningfully serve the purpose of ensuring that owners know how to operate guns safely in a way certain licensing requirements can. For that reason, registration requirements are often seen as a half-a-loaf measures aimed at deterring gun ownership. Because most of the United States has never required, and even now does not require, registration of all lawfully possessed firearms, DC's strict registration law is not long-standing in the United States. So after Heller, listen carefully, folks, listen very carefully. After Heller, some licensing requirements remain permissible, and some record-keeping requirements on gun sellers remain permissible. But DC's registration law violates the Second Amendment as construed by the Supreme Court. So there you have it. A licensing regime simply says you have a license to, let's say, carry a gun. It applies to you. It just basically, that's it. You do basic requirements. In contrast, the National Firearms Act, as applied to suppressors, is a taxation scheme and a registration requirement. Yet here, the Fifth Circuit said that the National Firearms Act registration and taxation scheme is analogous to a shall issuing licensing regime. But as you can see from Judge Brett Kavanaugh pointing out, these things are totally different. And they absolutely correctly totally different. Totally different. Because remember, the Fifth Circuit in this particular opinion today just said that suppressors are protected arms under the Second Amendment. They assumed that for the purposes of this opinion. Okay? As a consequence of that, because suppressors are protected arms under the Second Amendment, what does it mean? It means, number one, is you cannot tax them. You cannot tax their acquisition. How do we know that? Because there's two very straightforward Supreme Court precedents that we all know about. We all, except perhaps the three judges on the Fifth Circuit, know about. And that is the Harper versus Board of Elections that said a $1.50 poll tax on voting is unconstitutional because you cannot have targeted taxation on a constitutional right. And because, by the way, suppressors are now protected arms under the Second Amendment, you can't tax it. You can't have a targeted tax on them. That's illegal under Harper versus Board of Elections. It's also illegal under the Supreme Court decision in Minneapolis Star from the 1980s that says that a targeted tax on ink is also unconstitutional and violates the First Amendment. And again, because this Fifth Circuit opinion says we're assuming that suppressors are protected arms under the Second Amendment, that means they can't be targeted by the tax. Hello? Hello? How hard is this? Please. Please. This is why when I read this opinion, I told you it's like that CBS reporter about Taylor Swift's wedding. Oh my God, oh my God, oh my God. That was the best reaction I had, except my reaction was very negative. Like, oh my God, I can't believe this is happening. CBS reporter on the Taylor Swift engagement was happy, at least. I was not when I read this opinion. But let's go on. So there you have a registration scheme cannot be justified by licensing precedents. And now that suppressors are protected arms under the Second Amendment, textually, targeted tax on them, which is the $200 targeted tax under the NFA, is illegal, unconstitutional. So this panel screwed it up not only on the taxation angle, ignoring Supreme Court precedent, they also screwed it up on the registration angle because registering your gun, registering your suppressor with a serial number connecting it up to you is illegal and unconstitutional, as Justice Brett Kavanaugh said in the Heller 2. And yet this three-judge panel pretends that licensing regimes are the same as registration. And they're clearly not. Hello, this is not that hard. And to put one final nail in the coffin of this opinion before I think the Fifth Circuit in its entirety will en banc this panel decision and fix it. That's what I hope happens, assuming they seek en banc review. I don't know if they're going to, but if they do, I hope the Fifth Circuit does reverse this opinion and fix it. Here's what Judge Kavanaugh had to say in that Heller 2 case, pointing out that once an arm is protected under the Second Amendment, it cannot be registered. It can't have the taxation. It's just not allowed. Here's what he had to say in the Heller 2 case, and you'll see it applies specifically to this case here. And yet the Fifth Circuit, for some reason, ignored Supreme Court Justice Brett Kavanaugh. The U.S. Supreme Court decision in Miller analyzed whether the kind of gun Miller possessed, a sawed-off shotgun, was within the class of weapons protected by the Second Amendment. The Supreme Court's approach suggested, listen carefully, folks, it's very important. The Supreme Court's approach suggested that the government could require registration only, listen carefully, could require registration only of guns that were outside of the protection of the Second Amendment, namely those classes of guns that the government had traditionally banned and that were not in common use, such as machine guns and sawed-off shotguns. After all, if registration could be required for all guns, the Supreme Court in Miller could have just said so and ended its analysis. There would have been no need to go to the trouble of considering whether the gun in question, their short-barrel shotgun, was the kind of gun protected under the Second Amendment. Exactly right. That's my point. If a weapon is not protected by the Second Amendment, like let's say a nuclear weapon for the sake of argument, okay? Well, then, yeah, you can tax it and you can have it be registered because it's not protected by the Second Amendment. But once an arm is protected by the Second Amendment, in this case, suppressors, it cannot be subject to a targeted tax. That's illegal under Supreme Court precedent. And it cannot be registered for the reasons that Judge Brett Kavanaugh pointed out, including in citing to the Supreme Court decision in the United States versus Miller and Heller. Very strong precedent. And one wonders why this three-judge panel managed not to analyze any of this. I don't know. Not good. But anyway, we'll see what happens. Maybe the U.S. Court of Appeals for the Fifth Circuit will en banc this and fix it once and for all, because clearly suppressors are protected arms under the Second Amendment, and there's no historical precedent for requiring taxation or registration on protected arms in the Second Amendment. That is clearly a no-go zone under the Bruin analysis, and the Fifth Circuit ought to get this fixed. But again, the history of the future is yet to be written. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at @4boxdiner. Don't forget to subscribe both to YouTube and to Rumble. I look forward to talking again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.